Hi, I'm Joel Reedy, a founding attorney at Cornerstone Law Firm. Today I want to talk to you about the topic of how serious summary offenses are in Pennsylvania. Should you defend against a summary charge, or is it okay to just plead guilty? This is a common question I get from individuals who are charged with a summary crime. In Pennsylvania, we have several levels of criminal offense. The highest, of course, is a felony, the next is a misdemeanor, and the lowest is a summary offense. Summary offenses are very much like traffic tickets. In fact, many traffic tickets are summary offenses, but there are also non-traffic citations such as disorderly conduct, harassment, even shoplifting in certain circumstances. So often people call and ask, should I plead guilty and just pay the fine, or is there a long-term consequence to summary offenses? The short answer is that is a difficult question for many people to answer because it really can impact your long-term ability to get a job, to have a good name in public. There are a lot of negative consequences that can come from that. Summary offenses, especially if they're things like underage drinking charges, really can stick with you. They can affect your ability to get a job down the line. They do come up on background checks, and just because they're not formal criminal record doesn't mean that people won't know about them, and doesn't mean you won't have to explain them. I've had a lot of clients years down the line come back and say, I really wish I hadn't pled guilty to a shoplifting charge 20 years ago because it's affected my ability to get licensed, it's affected my ability to get a job, and now I want to expunge it. That can be done years later, but it's much harder to do than simply trying to negotiate or beat the charge at the time. If you're charged with a summary offense, you get two bites at the apple. Your first is at the magisterial district court, where you're allowed to have a full trial with the officer who charged you, with any witnesses, any victims of your alleged crime. And you also have the opportunity, if you want, to testify in your own defense. The magisterial district judge will then decide if you are guilty or not guilty. If you are found not guilty, it's over. You win. Double jeopardy protects you from ever being prosecuted again. But if you lose, you actually get one more appeal, and you get to have one more trial at the Court of Common Pleas in the county where your crime is alleged to have happened. So fighting summary charges is something that gives you a lot of tools. It's something that allows you to really challenge the charges, and in many cases, when we represent clients, we're able to negotiate those charges to something more manageable, something that won't have a permanent impact on their record. This can be done through the ARD program, which is a first-time offenders program available at many magisterial district courts. But it can also be done by discussing with the officer whether there's an ordinance violation or even just a lesser ticket that you could plead guilty to. In some cases, it's just by showing the police officer maybe that the alleged victim of your crime really was not harmed and that they lied to the police officer. So there are a lot of tools available to you. I think it's really important that you talk to a criminal defense attorney before you plead guilty to summary offenses. So if you have any questions about this video, feel free to give us a call. We'll be happy to talk about your options with you.